Hello, everyone. I'm Haley Hansen. Welcome to our webinar regarding the 2024 Title IX regulations. I am the leader of Husch Blackwell's higher education team. Before we begin, I'd like to cover a few housekeeping items. If you were on prior to us starting, you may have seen them in a few slides. We will At the bottom of your audience console, there are multiple application icons for your use today. If you have questions during the webinar, you can submit them via the question box. We will try to answer all questions during the webinar, but if a fuller answer is needed or we run out of time, we will try to follow up later. A PDF of the presentation is available in the program materials folder. So if you click on that, you're welcome to download the slides. This program has been approved for continuing legal education hours. For live attendees, you want to report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including the course number, will also be emailed to you tomorrow, along with a recording of the webinar in case any of your colleagues missed it today and you think it would be helpful for them to view it as well. Towards the end of the program, be sure to complete our short survey. That gives us ideas for future webinars, and we appreciate all the feedback and ideas that they have given to us. So that's all for our housekeeping items. So let's get started with our program. Joining me today is my partner, Derek Teeter. Derek has more than 17 years of experience in higher education law, and I have had the privilege of working with him during all of those 17 years. He represents private and public universities, colleges, major research institutions, and academic medical centers. People rely on Derek for Title IX advice in particular. In my humble opinion, he is a brilliant mind when it comes to all questions Title IX. So we're truly lucky to have Derek with us today. All right, so let's go ahead and get started. So why are we all here today? We're here because the final version of the regulations were released on Friday, April 19th. And as many of you know, these take effect on August 1st, 2024. What is covered in the regulations includes sex discrimination, sexual harassment, pregnancy accommodations, and grievance procedures. The regulations do not, and we want to be very clear about this, explicitly cover sex-separated sports teams. And we do anticipate that there's going to be regulations, assuming there is no change in administration, that would come out in 2025 that would discuss sex-separated sports teams. However, there is a lot of litigation right now. There's around 30 states who have enacted some sort of legislation, state legislation regarding sex-separated sports teams. So it's possible that one of those cases may work its way to the Supreme Court prior to the regulations. But if not, we anticipate those in 2025. So Derek, I'm going to turn it over to you to talk about whether we anticipate any litigation over these new final regulations.
Thanks, Haley. And well, to the question, will there be lawsuits? There already are. As of today, there are at least 4 different federal lawsuits filed in Texas, Louisiana, Kentucky, and Alabama that seek to block all or portions of the Title IX regulation from taking effect before August 1st. And those lawsuits are primarily brought by groups of states and then some advocacy groups. So we'll have to see how that litigation plays out. It's certainly possible that portions of the regulation, if not all of them, could be delayed or enjoined prior to August 1st, but that outcome is certainly not certain. And the outcome of where those cases would ultimately end up after appeals and making their way to the Supreme Court is also not certain. But we do want you to be aware that there's the possibility of some judicial intervention here. But unless and until there's a court order blocking those regulations, they take effect August 1st, and it's going to be necessary for you all to comply. But we want to test out some polling features that we use today. And one of the first questions we wanted to ask, there's not really a right or wrong answer here, is just what is your sense of how likely it is these regulations will get blocked? Do Do you think it's 100%, 75, 50, 25? You can pick the best option, or what you think is the best option on your screen, and then we'll show you what the answers are. So you should have the poll question now, and you can click A, B, C, or D. Give you all just a few seconds here. There's a lot of you on the webinar, so it takes it a while to update. Okay, I think you probably had enough time to pick an answer, so let's see the responses. Okay, so it looks like the largest portion of you put this at maybe a 50-50 proposition that will have some sort of court intervention. Another large chunk of you think maybe a quarter or 3/4. So this is a real possibility that we'll have some court intervention blocking these or parts of these, and certainly we'll all need to be attuned to that. Okay, so Haley, what do we need to do between now and August 1st?
So the most important thing that you need to do is start working on revising your policies and procedures. And again, we only have an hour, so we're not going to go through every potential change, but we're going to go over some of the highlights today of things that you will need to address within your policies and procedures, or at least talk about within your administration as to how does your institution want to handle issues as they arise, because you do have some choice in a few of these areas as well. And the other thing that you need to do is make sure that you updated your training content and train your key personnel. And we say that's before school starts. So we've gotten the question, is that before August 1st? Do we have to have all of our training done before August 1st? And the answer to that question is August 1st is, of course, the implementation date. Anyone who is going to be administering Title IX at your institution after August 1st needs to be trained at the time in which they're working on their first case. And so if your first case comes in on August 2nd, you'll need to make sure that individuals are trained before working on that case. And so looking at those, but making sure again that your training content is updated and that you have your key individuals that they've received training. All right, so let's talk a little bit about some of the key elements or changes that we see with the final regulations, and what are the things in terms of your policy that you really need to work on and updating the policy prior to August 1st. So I think I want to reiterate this. I said it the last slide, but this is a summary of the changes. We're not going to cover everything in the regulations in its entirety. And some portions of the regulations actually haven't changed or have changed in a slight bit. So make sure that you're working with your legal counsel regarding changes. Make sure you have a multidisciplinary team that's working on updates to your policy, and that the changes that you make, people feel comfortable can be implemented on your campus. So Derek, I'm going to turn it over to you to just talk about some of these key elements or key changes.
Thanks, Haley. So we've grouped these by topic, and the first slide we've categorized as broader scope. And this is one of the key themes of the new regulation. It's going to capture a much larger universe of misconduct that will have to be subject to these explicit grievance procedures and the scope of your Title IX policy. So one thing the new regulation does is it includes this broader concept of sex discrimination, not just sexual harassment, but sex discrimination, including just treating someone adversely because of their sex, or maybe what we would call programmatic sex discrimination, where the institution, through its policies, is blocking access to certain courses or underfunding certain programs. Those types of classic sex discrimination, if you will, have always been banned by Title IX, but there haven't been regulations dictating the particulars of how those non-sexual harassment cases get investigated and adjudicated. And now they are going to be subject to these very explicit provisions for notice and investigation and determination. And a lot of those could include complaints against the institution itself, not just individual bad actors. So we have this broader scope of sex discrimination and sexual harassment being the subject of these exquisite particular means of investigating and adjudicating cases. We also will have expanded geographic scope. We know that Title IX is a statute that applies to discrimination in education programs and activities. The new regulation says that's going to reach out and capture some acts of sexual harassment that may happen off campus in private settings if they have a connection or if they contribute to a hostile environment that does occur in physical space the institution controls, or, and I think this is going to be a really big expansion, if they occur in settings where the school has disciplinary authority over the parties irrespective of Title IX. So, for example, if your student code of conduct purports to regulate the actions of students wherever they go, you're exerting disciplinary authority over them in off-campus locations, and the Title IX regulation would have Title IX jurisdiction follow the scope of your disciplinary authority. So we're going to have more instances get pulled into a formal Title IX process than we would have had under the August 2020 regulations. We also have a broader definition of what sex is for purposes of both sex discrimination and sexual harassment, and the regulation codifies this current administration's sort of long time position that sexual orientation, gender identity, pregnancy status, also related characteristics like gender stereotyping, sex characteristics are all part of sex. And so discrimination or harassment that is motivated or based upon any one of those things would be a form of sex discrimination that Title IX would cover under the regulation. So that's, again, pulling in more examples of conduct that would be subject to a formal Title IX policy. So Haley, you want to walk us through an example?
Yeah, we'll put you on the spot, Derek, and walk us through an example. So student A accuses student B of committing a sexual assault during a study abroad program. Student A alleges after returning to campus in the U.S. that student B sent student A unwanted and provocative text messages. So under this broader scope, Derek, what is your analysis?
Yeah, so this is an example of one of these incidents that happens sort of outside Title IX's formal scope, but nonetheless is connected to and maybe contributes to a hostile environment on campus, which would be within Title IX scope. And the regulation says you investigate what happened abroad as part of your analysis of whether there's a hostile environment on campus from the unwanted provocative text messages. The August 2020 regulation didn't really have that built into it. It has a sort of very rigid, if it happens outside the country, you don't investigate it sort of structure. And now the regulation says if you have that connection, it would be part of your investigation too. So this is going to pull in potentially things that happen abroad when there is follow-on conduct that happens within campus or programs and activities in the United States.
And I think one of the things we always also just want to remember, although this is certainly not a Clery webinar, is that you still, even though that Title IX is not applying to the sexual assault which occurred abroad, may be brought in, as Derek just explained, you still have Clery obligations as well, and make sure that you follow those Clery obligations if it's within your program of study. So, okay, let's put you on the spot again, Derek. Kyle, a transgender male, alleges that Professor X has made negative comments about transgender persons during class and graded Kyle harshly because Kyle is transgender. So how would you handle this one?
Yeah, so this example illustrates sort of multiple instances of how we have a broader scope. I mean, most obviously, Kyle's transgender status under this regulation is a form of sex as a category. And so we would have here both potential sexual harassment in the form of negative comments that are based on or because of Kyle's transgender status. And then we also have this differential in how Kyle is being graded more harshly relative to other persons. And that's really a form of adverse treatment discrimination, which again, before the current regulation, we didn't have sort of exquisite directives about how to investigate and adjudicate that, and now we do. So we have the gender identity element, the sex discrimination element, and the sexual harassment element all baked into this example. Okay, we've got some other changes that also are going to bring in more cases, but let's look at these modified definitions. So in addition to sort of these broader scope issues, which you might think of as sort of jurisdictional questions, the new regulation also modifies some of the substantive definitions of the various types of misconduct in a way that will pull more instances into a Title IX policy. One, the definition of quid pro quo harassment is being expanded. It used to be when just an employee of the institution conditioned an aid, benefit, or service on unwelcome sexual conduct. And now it's not just employees, it's any person who's exercising an authority that the institution bestowed upon them. So it could be a board member, could be a volunteer who's been granted the ability to confer some benefits. So that's a broader definition of quid pro quo. The Title IX definition of hostile environment harassment is being brought into essential alignment with the Title VII definition. So the August 2020 definition under Title IX said it had to be severe and pervasive and objectively offensive. And now it's subjectively and objectively offensive, and it's either severe or pervasive. So we have that and being replaced with an or, meaning you could have some singularly severe incidents that can create a hostile environment. The definition of retaliation has been clarified, if you will, to say that if someone is being punished with ancillary student conduct charges because of their exercise of Title IX rights, that's retaliation. It's clarified to say that peer-on-peer retaliation is a violation of Title IX. There's a helpful clarification under the definition of retaliation that also says it isn't retaliation to require an employee to participate in a Title IX process as a witness, which under the prior definition, there was some debate about whether that could be done. And I think this is good because it will allow institutions to make sure their employees who view or see or have information about sexual harassment have to support the institution's efforts to address it. The definitions of sexual assault and the various VAWA crimes, dating violence, domestic violence, and stalking, are essentially the same as they were under the August 2020 regulation. The sexual assault definitions, which track the FBI's terminology in the National Incident-Based Reporting System, or NIBARS, have consolidated some of those categories under the category of rape, but still it's the same conduct, simply sort of changing the rubric in which it's defined. So those are the modifications to some of the examples. Okay, let me pose a hypothetical and then we'll get Haley's take on it that implicates some of these changes. Suppose that we have a student named Lane who comes back to the residence hall in a drunken stupor and approaches a group of students gathered in the common space and then displays Lane's genitals for several seconds. So it's a sort of a flashing incident, if you will. Haley, what about that? How would that be treated under the old regulation and the new one?
Well, I'm going to ask a poll question about the old regulation, but this example illustrates the new definition of hostile environment and why it may matter in a lot of the institutions work to do an analysis of whether or not a hostile environment has been created. So let's launch this next poll question. Would Lane's behavior constitute hostile environment sexual harassment under the August 2020 definition? So yes or no? Okay, so you just need to click A or B. Hopefully, there we go. Okay, give you just a few more minutes, a few more seconds. All right, so we've given you enough time to answer. Let's go ahead and share the results. So 73.6% of you said no, which I think is the right answer because it is a single incident. and thus not going to be pervasive under the old guidance. I think under the 2020 regulations, I think though, as you kind of think through how this definition has changed, and again, has the elements of subjectively or objectively offensive, and then it is either severe or pervasive, again, aligning more with our Title VII definitions, that there's going to be additional cases that are going to be a much closer call to determine whether or not they meet that definition. So let's talk about mandatory reporting. All employees, it was very clear at K-12 schools, are mandatory reporters. So you must have in your policy that you're mandatory reporters and who to report to, your Title IX coordinator. Many higher education institutions and the new regulations are also mandatory reporters, and those include anyone with the authority to institute corrective measures would be a mandatory reporter, administrators, faculty, and advisors. However, I think we're going to have policies that really have a broader scope of mandatory reporting, and I'll tell you why. For employees who are not mandatory reporters under the new regulations, they must still either report to the Title IX coordinator if they learn of sexual harassment or discrimination or something that falls under Title IX, or provide the reporting party contact information for the Title IX coordinator and information about how to make a report. And so to an extent, even if you are not considered a mandatory reporter in higher education, you still have those obligations. And in training, it will be confusing potentially to some employees. So it may just be easier to have everyone be a mandatory reporter. Confidential employees are still excluded, but again, only to the extent that they are acting in their professional capacity when they learn of the sexual misconduct. So again, confidential employees still need to understand that they are confidential employees and are acting as such. So an individual who may be a counselor or may be a member of the clergy or someone like that, but is not acting in that professional capacity when they learn of the sexual misconduct, is not going to be a confidential employee. They actually, again, they do not have to make the report if they're acting in their professional capacity when they learn of the misconduct. All right, so complaints. As you recall from 2020, this concept of a formal complaint. We had to have a formal complaint that was filed. It had to be in writing and signed by the individual. All of those concepts are gone now with the new regulations. The new regulations say that you can make a complaint verbally and you do not have to have a signature. It also expands who can make the complaints and when. And so the alleged victim need only be a participant at the time of the misconduct to make a complaint of harassment, which is different from the 2020 regulations. So this will be different in your policy as well. So it's at the time of the misconduct, the alleged victim must have participated in your education programs and activities. Also, persons with the legal authority to act on behalf of the victim are also allowed to file complaints of harassment on their behalf. And so a wider area. So these are parents of a minor, guardians of persons who are under conservatorship. Those are examples of persons with that legal authority to be able to act. And I know we all have, or a lot of institutions of higher education have minors on campus. And so that's important to have as part of your policy as well. And then finally, as it pertains to
Haley, I think we lost your sound. I don't know if you can hear me. Okay, so we're going to send someone in to fix Haley's sound, and I'm just going to take over and move us forward while we get that remedied there. So our apologies for that. So we were looking at this example with Chaz, who's a student who graduated 2 years ago. And Chaz called the Title IX coordinator to report that while they were a student, an assistant coach propositioned Chaz for sex. And Chaz says to the Title IX coordinator, you should look into this and fire the coach. And so if we looked at this example under the regulation from 2 years ago, we don't have a formal complaint because it's not in writing. And we have a complainant who is not a current participant or attempted participant. So they couldn't make this complaint. Only the Title IX coordinator could. But under this new regulation, the one that's going to take effect August 1st, Chaz was a participant at the time of the alleged quid pro quo, and Chaz is verbalizing a complaint of something that could be harassment and indicating a desire for an investigation, and that would be sufficient to constitute a complaint under the new policy. So that's a sort of a key distinction that, again, is going to prompt more cases to run through the Title IX process than otherwise would. Okay. Our next conceptual change.
Can you hear me now?
I can. Great. We got it fixed, and we're on your interim.
I think we have it fixed, but could somebody just on the chat just say that we've got it fixed? If you can hear us or hear me. Yes. Okay.
Yes,
thank you so much. Thanks. Okay.
Yep.
Could you just move this screen? Yeah. All right. So interim removals. Interim removals. Okay, great. We fixed it. Thank you very much. Sorry for our technical difficulties. Not sure what happened. I'm sure I must have hit something. So apologies. So interim removals. What happens with interim removals? The big change that was eliminated from the 2020 regulations was eliminated the requirement that you have a threat to physical safety. And so you can still have an interim removal. Largely the same as we saw before, but it could be an immediate threat to mental health or safety. That would now suffice. So you still have to have an individualized assessment and determination. So you must have a process for interim removals and a team approach to deter, or we think a best practice is a team approach, but you can interim remove someone now for physical or mental health or safety. And so that's an important change to include in your policy revisions as well. And you still need to provide the right of immediate appeal if you are going to remove someone. All right, Derek, I'm going to turn it back over to you before my sound goes out again.
Okay, so our next category is supportive measures. So this is a concept that came from the prior regulation. It's still a concept that's baked into the one that's about to take effect. But we have some clarification of some important points. Supportive measures are essentially intended to preserve a person's access to programs or activities, to maintain the status quo, to make sure we don't have additional harassment occurring while we're doing an investigation. The new regulation explicitly says, therefore, this can't be something that you impose for a punitive or disciplinary reason. So we can't have a punitive or disciplinary motivation for imposing something like a no contact order, or maybe a housing change where we move the respondent into a different location. It can never be done for punitive or disciplinary reason. The regulation also imposes what I call a least restrictive means limitation, which was sort of a good practice even before the regulation imposed it. And essentially what this says is, look, if you're going to have supportive measures that burden one of the parties, take, for example, that burden the respondent, maybe a no contact order or a housing relocation, you should only impose the minimum burden necessary to address the concern that you have. So you couldn't have a rule, let's say, that every time you get a complaint, you necessarily are always going to impose a no contact order and a housing relocation, because that may be unnecessary in certain cases, maybe where there isn't a threat to physical safety or nothing happened in housing. So you have to tailor it to the needs of the case under this least restrictive means sort of rule. Now, a significant change that I think you're not going to like as Title IX practitioners is the new regulation grants the parties the right to appeal supportive measure decisions that they disagree with. And it also gives them the right to request a change in supportive measures if there's a material change in the conditions, and then they can appeal if that change request is denied. So you have to have someone who's responsible for deciding what supportive measures to provide, and then you also will have to identify a supportive measure appeal officer to whom parties can appeal if they don't like the fact, for example, that you've imposed a no contact order, or if someone has requested time off from classes and you've only granted part of what they've wanted. Those will now be the subject to sort of very quick appeals up the chain to someone else. And it's just going to make cases more tedious, especially those cases where the parties are disagreeing about everything. It's another sort of point in which these cases can be litigated. And it's going to create more work for you, is the long and short of it. Okay, the next concept is dismissal. So we know from the August 2020 regulations that there's this idea that when certain triggers happen, we might dismiss a case out of a Title IX policy. Maybe it gets sent somewhere else. Maybe it just goes away. And the August 2020 regulations delineated between mandatory grounds for dismissal and permissive grounds for dismissal. And the new regulation does away with mandatory dismissal entirely, and all dismissals are permissive in the sense that they are not necessarily required. The regulation says that dismissals, as a general rule, should be unusual and should only be taken after there are sort of additional steps to try to clarify allegations, to find sufficient evidence, etc. So think of it as treating dismissal as sort of a disfavored approach, where maybe under the prior regulation, dismissal was certainly not disfavored and was even mandated in certain categories. Now, under the new regulation, the grounds for dismissal, although they are permissive, are similar to what they were previously. You would be able to dismiss if you were unable to identify who the respondent is after reasonable attempts to do so. You could dismiss if the respondent, the alleged bad actor, is no longer a student or an employee, so they've separated. You could dismiss if the complainant voluntarily withdraws their allegations and you conclude that in the absence of those allegations, there really is insufficient evidence to make a finding. And you can dismiss if the conduct alleged, even if it is proven to be true, could not constitute sex discrimination or sexual harassment. So the triggers are similar, but it's permissive instead of mandatory, and we have a little bit of changing on the edges of it. Okay, so then we get into one of the most, I think, significant changes, and the one that people are talking about a lot, which is changes to how the grievance procedures actually function. So one important conceptual distinction the regulation makes is between what I'll call the general grievance procedures, which apply to all cases of sex discrimination and sexual harassment. And then we have special heightened procedures for higher education cases involving sexual harassment and a student complainant or a respondent. Okay, so think of the general default, and then for certain classes of higher ed cases with student parties and sexual harassment, we have special, more rigorous procedures. So we have to think about both of those in terms of how we might build out a policy and how we would, handle a case as it's processed. So the general procedures, if you will, which would apply by default unless we have higher education and a student party and sexual harassment, they include the same sort of fairness principles that the current regulation has. They include the equity requirements. They have notices. There's a presumption of non-responsibility until the evidence supports that someone did violate a policy. Evidence is restricted to relevant evidence, and we have the prohibition on sexual history, et cetera. So those are all sort of similar points. There are fewer elements that have to be provided in writing. For example, the notice of allegations. There are fewer elements that have to be included in the decisional documents. The general procedures don't require the use of advisors as far as Title IX is concerned. There could be some Clery Act requirements separate from that. And they don't require the use of a live hearing, although they do require the decision maker, which probably is going to be an individual under these general procedures, to have the opportunity to ask questions of the parties and witnesses where it's necessary to determine credibility. So these general procedures, which start to look a lot more like a single investigator model from pre-August 2020, albeit with some important augmentations, are going to apply in the K-12 setting. They're going to apply to employee-on-employee cases in the higher ed setting, but they're not going to govern college and university student cases where we have sexual harassment. That's where we get into the more particularized procedures. And certainly all the ones that involve student-on-student higher education sexual assault. Okay, so what about those heightened procedures, if you will? We still have the rigorous written notice requirements similar to the August 2020 regulations. The initiating document that articulates the who, what, the when, where, and the how, has various necessary elements. The parties have the right to be accompanied by advisors. There's the right to appeal dismissals. There has to be a mechanism that permits the decision maker to question parties and witnesses about credibility issues. And then we have some choices about how we will satisfy the need of the parties to be able to question each other, which is sort of a due process imperative in these cases. And the way that we would suggest thinking about those options is maybe there's three different kind of types that your policy might have. You could have what we call an augmented investigator model. You could have an investigator adjudicator model, or you could still have a live hearing. All three of those are potentially viable sort of decision-making paths under the new regulations. So let me just unpack those three things a bit. The augmented investigator as decision maker model. Okay, so there's been a lot of sort of generic commentary that the new regulations go back to a single investigator decision maker model. And A, that's not true insofar as that isn't mandatory, but B, to the extent a single person could serve as investigator and decision maker, it will not operate in the way that it did prior to August 2020. At least as far as these higher education student-on-student sexual harassment cases are concerned. So here's what we know. Your investigator has to be allowed to ask the parties and witnesses relevant questions, including those that bear on credibility. And that would happen in the investigation phase in the same way it does now. But you have to have some iterative procedure that would allow the parties to propose questions that they would want the investigator / decision maker to ask of the other party and witnesses. So using the investigator as sort of the intermediary to pose relevant questions, including those that you would characterize as cross-examination. And the real trick here is the regulation says the school must provide parties a recording or a transcript of the initial interview so that they can see what a person said, so that they then know what follow-up questions they want to propose, to have the investigator then go back and ask those questions in a second interview, if not a third or fourth, depending upon how many iterations we go through. So that's not a simple process. It necessitates, at a minimum, initial interviews with parties and witnesses, and then the preparation of a transcript or an audio recording and providing it to the party to listen to and then propose questions to have them go back and be asked again. And obviously that can have more than one cycle depending upon if people say additional things. And only after that iterative process is completed could the investigator then, as the decision maker, issue a written decision. So this is not going to be quick like it used to be when we had sort of a true civil rights model of investigator decision maker under the Obama administration. And I think if we do go down this route, there's some tedium here in terms of preparation of transcripts and recordings and providing them and going back and asking questions. Now, one other approach, which we call, oh, well, let me ask you a poll question first. What do you think about that? Is the augmented investigator as decision maker model less burdensome than a live hearing? So knowing what I just said, that you would have the investigator do the investigation and make the decision, but there's this back and forth, and here's the transcript, and what do you want me to ask them now? And I'll go back to them. Does that sound less or more burdensome than just doing a hearing? So we'll give you all just a moment to look at that. Okay, so with a lot of you having responded, probably not all, but a lot. Okay, 62.5% of you say, you know, that's not really less burdensome than a live hearing. Or it's another way of saying that looks pretty burdensome too, which is interesting. It may cause some of you to say, you know what, maybe we'll just stick to the live hearing because it's the devil we know, and this alternative is not going to be that more efficient for us. Another model that does seem possible under the regulation is what we would call the investigator adjudicator model. So this idea would be the investigator conducts the investigation like they normally would, and they ask parties questions that bear on credibility, and then they give the parties access to the evidence or a report summarizing the evidence, including those transcripts of interviews or recordings. And then we have a separate individual who we'll call a decision maker, who instead of conducting a live hearing, has subsequent meetings with the parties and witnesses, where that decision maker can ask questions and also can ask questions that the parties propose. So again, using this person as an intermediary, but this person is different than the investigator. Think of this as sort of like an iterative hearing, the way some of you have sort of informal hearings under your student conduct process, which are fundamentally a series of meetings with a decision maker. This model is possible, but also not simple and straightforward because you still have all the interviews, and then you'd have to have these separate meetings with the decision maker and these mechanisms for ensuring that the parties get to pose questions through the decision maker to be asked of the other parties and witnesses. And then, of course, the third option is simply to keep a live hearing model, which the regulation allows. And it's largely a live hearing that looks a lot like what we have today. The decision maker, whether that be a single person or a panel, is interacting live with parties and witnesses and asking them questions that are relevant within certain restrictions, like you can't look at sexual history. And then the parties still in this live hearing have to have some mechanism to pose questions to the other party and witnesses, either by routing them through the decision maker, so like passing your questions up to a hearing panel chair and having them ask them, or using an advisor to ask questions on their behalf in the way that the current regulation is structured. What you could not do under the new regulation, and you can't do today, is allow a party to directly cross-examine the other party. That's prohibited. So to put a pin in it, there are some different possible decision-making models under this new regulation for cases that involve college and university students and sexual harassment. But all of those models are still fairly tedious and are going to require a lot of institutional energy to get from the start to the end. Okay, I'm going to turn it back to Haley now to walk us through a few more sort of topical changes.
Thanks, Derek. And I think one of the questions, or we got lots of questions that came in during these are three models, and that you and your policy would choose between the three models. I think there were some questions that you had to offer choice to the students of whatever model they wanted, and that is not how this is set up. These are three options of how you want to set up your policy that Derek was walking you through. So, all right, let's talk a little bit about the cross-examination and weight. So the exclusionary rule has been eliminated. And so that was put in place in 2020. There was lots of discussion regarding it in 2020 and after. And in fact, there was an injunction that you could not put the exclusionary rule into effect. The department weighed in on that. Is there no volume again, Derek?
I can hear you.
Can you hear me?
Yeah.
Okay. All right. Sorry, I heard somebody said that they can't hear me again. But Emily can hear me too. Okay. All right. Great. So now I'm nervous about it, of course. So essentially, with the exclusionary rule being eliminated, then it's really up to the decision maker to decide how much weight or no weight at all to place on the statements where a party or witness refused to respond to relevant questions. So that may be that they don't show up or that they simply do not answer relevant questions. So it really goes back to the decision maker making a determination as to the weight and the credibility of the witness's refusal to, or witness or party's refusal to respond. And I think this could cause some angst and issues for institutions, only because you may have different decision makers, and they in one case may exclude everything that that someone refused to answer and provide a different weight, and so to another process. And so I think it's going to be hard with this being the requirement to have consistency among your process, especially if you have if you have multiple decision makers within your process. So be aware of that. All right, so let's ask our next poll question, which is, my institution is likely to A, keep our current hearing model, B, switch to an augmented investigator as decision maker model, or C, switch to an investigator adjudicator model. So I'll give you just a few seconds to respond. But if you pick one of those three, what do you think your institution is likely to do in your policy? All right, since we're running a little short on time, I'm going to stop there and I will show you the results. So that's what we're hearing anecdotally too from our clients, is that a lot of people are just going to keep their hearing model, that they may make some changes to it based on the new regulations, but they are likely going to keep that hearing model. Although, again, 25% of you say, or 27% to switch to the investigator adjudicator model. So when you look at that, I think everyone is probably weighing the pros and cons to a lot of these models to decide what actually works best at your institution. All right, informal resolution. So this is, no formal complaint is now required. So no formal complaint predicates the informal resolution process. It's now also permitted for claims that an employee has harassed a college or university student, unless you have a state law or local law, or there's some sort of conflict with federal, state, or local law. And so you are permitted to engage in informal resolution. So this gives you a lot more options than under the 2020 guidance or the 2020 regulations, in which you had to have a formal complaint in order to initiate an informal resolution process. One very important point is that the investigator cannot facilitate informal resolution. You need to make sure that that individual, of whoever is facilitating the informal resolution, is not part of the overall formal process to be an adjudicator or part of that process, including the investigator, because they would be involved in the informal resolution. I talked a little bit at the beginning of training. I want to just talk about this just a little bit more. So what are you required to do for trainings? Most institutions are already doing this, but the subject matter and content of the training will need to be updated. So first, you have to have a mandatory basic training for all employees at hiring and annually. So you need to have a basic Title IX training. And then you need to have role-specific and detailed training for any person who's playing a specific role within your Title IX process. And so that needs to occur as well. Again, the regulations, if they are not barred by a court, go into effect on August 1st. And so the training, we don't believe the training needs to all be accomplished. A lot of you haven't even gone back to school on August 1st, but you need to make sure that anyone who has gotten a complaint under the new regulations has been trained in your new policy after that complaint comes in, if they're going to adjudicate or have any specific role in that. I still think you can do your mandatory basic training for your employees, as you normally do with your back to school trainings or at the beginning of the year. The one other change that's not on this slide that I think is important is that we saw a kind of a rash, I would say, of the last 6 months of OCR complaints against schools for failing to place their training on their institution's websites, and that was under the 2020 regulations. You are not required to post anymore. That has been changed, but you are required to provide any training materials if requested. So if someone requests those materials, you've got to provide those materials, but you're not required to post them on your website moving forward. So that is kind of a little bit of a different caveat there as well. All right, so one of the big changes is pregnancy and pregnancy-related conditions, and something that we really want to talk about. So this really codified pre-existing Title IX guidance, and in all likelihood, institutions will want to issue a separate pregnancy accommodation policy that really outlines your process and parameters of getting accommodations for pregnant students. It's important, I think, as you look at these bullet points. So discrimination and harassment based on pregnancy or pregnancy-related conditions is prohibited. Institutions must provide reasonable modifications based on individualized need. You don't have to fundamentally alter your education programs, but that's a high bar, as we all know, under our accommodations process as well. The right to reinstatement to an academic status when the leave began is going to be part of this, and the explicit rights and requirements for lactation spaces, and enough lactation spaces that are going to be allowed. And this is not only part of the Title IX regulations, but the regulations that came out regarding pregnant workers, the Pregnant Workers Fairness Act regulations, which came out right at the same time as our Title IX regulations, that really hit hard regarding lactation spaces. So again, that need for space and excusing individuals that need to use lactation spaces is going to be important as well. So really, this last bullet point, the limitations on to document demands, really is going to impose that you can't impose unreasonably high documentation standards, and that you need to work with individuals regarding accommodating and reasonable modifications based on their pregnancy status. So pregnancy reporting, this is another change that you need to be aware of. So if a student informs an employee, and this is any employee, not just a faculty member, that the student is pregnant or has related conditions to pregnancy, the employee must provide, and must being the key word, the student with the Title IX coordinator's contact information, and tell the student that the Title IX coordinator has the authority to prevent discrimination and ensure that they have equal access with their pregnancy or pregnancy-related conditions. And so that's going to be very important that you have in your training that all employees must do this. And I would really encourage you to think about in your pregnancy policy to have some way that your employee documents that this has occurred. A lot of times these are verbal conversations, and the faculty member or the employee will think that they have informed the pregnant student, and then the pregnant student will think that they're going to somehow get accommodations or modifications to schedules, or that this is already in place because of that conversation. And when in fact, all that the employee is required to do is to provide them with the Title IX coordinator's contact information. So if the student contacts the Title IX coordinator, the Title IX coordinator is then informing the students of legal rights, including those rights to reasonable modifications. So really encourage you to have some way in which your employees document, either sending an email to the student so you have a documentation of what you discussed and the information that was provided, or sending an email to the Title IX coordinator that this occurred, because it's very difficult then, as we've seen in accommodation related cases, for the student will say, well, I assumed that since I told my faculty member this was all going to happen for me, and the faculty member said, no, I just referred them to this office. I didn't do anything else, and so therefore, the modifications did not get in place, or did not go in place. So this is going to be a big change and something that you need to make sure you're training all of your employees on. So here's the example. Jane remarks to a faculty member after class that Jane is pregnant and will have her first sonogram next week. Jane does not ask the faculty member for any modifications or accommodations, or otherwise indicate a desire for any modifications or accommodations. So does the faculty member A is not required to do anything because Jane didn't ask for anything, or B must provide Jane with contact information for the Title IX coordinator and describe generally the authority of the Title IX coordinator to protect and support pregnant students. So I'll give you just a few seconds for this one because we're quickly running out of time. And I think I've already given you the answer. So, oh my gosh, we got 100%. I love it. Okay, that's the answer, 100%. So let me turn it back over to you, Derek, to talk about gender identity.
Okay, yeah, we just want to hit a couple of points at the end here, which we've already sort of lightly touched on. Gender identity is defined in the new regulation as a species of sex discrimination and sexual harassment. And there's some specific guidance that says an institution must not engage in differential treatment or separation from certain programs or activities that causes more than de minimis harm. And it goes on to say that differential treatment or separation based on gender identity subjects a person to more than de minimis harm, which is a way of saying that sort of gender identity-based separation or exclusion violates the regulation unless it governs or applies to a specific statutory scenario where Title IX allows separation. And housing and athletics are the two scenarios where the Title IX regulation itself has sort of special rules. And so that's one of the reasons why we're telling you we have to wait for the athletics sex-separated team rules to be in place before we know fully how this is going to play out in athletic space. Same is true of housing. I've seen a number of questions. What does this mean for religious institutions that may have a theological disagreement with some of the underlying assumptions? The regulation does not modify Title IX self-executing religious exemption. So Title IX does not apply to a religious educational institution to the extent that it conflicts with genuinely held religious beliefs of that institution. So some of you may, as religious K-12 or higher education institutions, claim an exemption from certain aspects of the new regulation to the extent that it conflicts with religious beliefs. And this particular subject may be one where there is some conflict for some of you. Athletics. The main point here is we need to wait for finalized regulations dealing with the athletics sex-separated teams specifically. That probably isn't going to tell us what to do with bathrooms and locker rooms. It's going to tell us how teams themselves are structured. And so we're going to have to probably wait for some additional guidance from the courts about bathroom and locker room facilities, separate and apart from teams, and maybe even with teams as well, to the extent that we don't have competition or safety concerns, which maybe for some, co-ed rec sports are not going to be as prominent. So there's more to come there. Okay, a number of you have also asked, are you going to do training, Husch Blackwell, on Title IX coordinators, investigators, the sort of more significant work that we need to do prior to the start of school? We will. I think invitations have already gone out yesterday. There'll be follow-up ones, but we have 3 8-hour sessions scheduled in June, July, and then 2 half days in August that you could take advantage of if you wanted to. Okay, well, we covered a lot, and you had an awful lot of questions, I think over 120 of them. Maybe we can just quickly hit, 2 or 3, but we're going to have to follow up with you on those. Okay, I know someone said, well, what about when we select our different decision-making models? If we have, parties that don't want to be near each other, they don't want to be in the same room, do we still have the ability to utilize Zoom or Teams or virtual environments? Can we still do the room separations if we need to? The answer to that is yes. Those logistical arrangements to separate people who don't want to be in each other's presence are all still possible under the regulations. Haley, why don't you pick a question or pick one while I find another one here.
Okay, so we had some questions. Oh, can you hear me? Okay.
Yep.
Regarding pregnancy, and I think, some frustration potentially of, how many times the student will likely get information regarding the Title IX coordinator. And that is what is required. So you can't just assume that somebody else will give them that information. You've got to document it. The other question that I got was, well, I gave the example of a faculty member, which is probably the most common example. What about the example of the maintenance crew or groundskeepers? And it says employees, and so it says all employees. So I think you have to make sure that they are trained, and during your trainings that they know that they are who the Title IX coordinator is. And that's, when you do these back to school trainings, whether you have someone from the outside do them or you do them yourself, that's number one, is who the Title IX coordinator is at your institution and how to get a hold of them so that they are at least aware of who to send that student to. The likelihood that that happens may not be great at your institution, but you still need to make sure that the training is conducted.
And then let's do just one more. Someone said, with regard to the different models, can we pick one, or can we move between the 3 of them depending on the case? I think our advice to you is you need to pick the model that you want to use for the sexual harassment, higher education, student-on-student cases, or where there's a student party. You shouldn't have a policy that allows the Title IX coordinator to utilize different processes depending on the case, unless it is a different type of case that doesn't involve sexual harassment. So you just need to make some decisions about what model you think is going to be best for your institution, and then write it into your policy.
Eric,
Okay.
let's do one more that is just very, very, very quick. So that is when you talk about recording or transcript, we got like 6 people ask whether or not your notes would be sufficient. So what do you think about that? Does that meet the definition of recording or transcript?
The regulation says recording or transcript. It doesn't say notes or summaries. And transcript typically is understood to be a verbatim, word-for-word accounting of what was said. So I would be pretty nervous about relying upon just notes or a sort of summary to check that box. I think they're looking at an actual transcription typed out. Wouldn't necessarily have to be a court reporting service that does it, but it may be an AI-generated transcript, or you may have an assistant, a professional staff who can type it out, but it probably needs to be more than notes or a summary. Okay, well, we want to be mindful of your time, so we'll go ahead and bring our webinar to a close. Thank you for joining us today. We hope the information was helpful. Just as a reminder, the program has been approved for legal education hours, and you can click the CEU icon at the bottom of your screen to report that to your state if it's one where we are approved. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a link to a recording of this webcast that you can look at or that you can share. We'll also send you a short survey link. We appreciate your feedback, and we'll use it as we design future programs. This concludes our webinar. Thank you for joining us today.